Hello, welcome to the 2020 Legal Services Forum for Illinois Realtors virtual business meetings. Some of you have joined some of our other forums. I think this is the third or fourth one. And Annalise, you can throw your video on right there. And to introduce myself, my name's Betsy Urbance. If we haven't met before, so if you're a first-time attendee at one of these meetings, welcome, welcome. And if you're someone who's come to many of our meetings, welcome to our e-forum, if you will. I'm Betsy. I'm the General Counsel at Illinois Realtors, and joining us today is Annalise Fierstos. She's Illinois Realtors legal hotline attorney. We're going to spend the next hour, so we're going to be talking fast because for y'all, an hour might seem like a really long time, but for lawyers, that's like lightning speed. So we're going to try to share with you just about everything we can think of right now that might be of importance to you on the legal landscape. And to kick it off, I'll give you a little overview. We'll have two sections. Section number one will be Annalise sharing with you the hot topics section, the 5 or 6 hot topics that are currently coming through the hotline, because as we have learned over the years, the hotline is the pulse of what's going on out there in the marketplace. So even if some of the subject matters that are being discussed seem like old ones, they're current because they're happening right now, and every other call Annalise is getting cover these topics. So she'll share those with you. And then after her section, I will share with you legal issues outside the hotline that we are also tracking on behalf of our membership in the industry. And I will also talk about a few interesting cases that you might want to know and maybe have some takeaways as far as the lessons of the case from each of these. So without further ado, Annalise, you can unmute and take off with the hotline topics.
Thank you so much, Betsy. I thought I was nervous last year at my first fall business meeting when I had to speak live to people. And I find that the Zoom presentations are very disconcerting. So forgive me as I look down at notes frequently and kind of overcome looking at my own face on the screen. I don't know if anybody else feels that way, but it's not that much fun. It's been an interesting year, as everybody knows. 2020 has been very interesting, and it completely shifted all of the issues I dealt with coming into this job to a whole new area that we're dealing with. Starting in March, when we first started heading home and we were working remotely and everybody was dealing with the impact of the pandemic, the hotline was flooded with a lot of COVID-related questions that included the impact of the executive orders on the open houses and on the showings and all of the direct impact that was being made upon the real estate industry as far as limited access to the clients and limited ability to show real estate. Things have really evolved since then. So I'm not getting those COVID-related questions in that sense now, but I would direct anybody who's dealing with some of those issues as they continue to flow in, I would direct them to the Illinois Realtors webpage, because we have compiled FAQs that continue to address open houses, tenant occupied showings, and similar issues along those lines, including reopening of offices and guidelines for reopening offices. Go to the webpage and take a look and see how things have evolved on the webpage with the information we're supplying, and take a look at the links that we have to our local resources, the DCEO guidelines about opening up your offices, and other issues that are related. But in the last, I would say, 12 weeks, the hotline is now receiving questions that are caused by the fallout from COVID and the impact on the industry. And one of the questions that I'm getting most frequently pertains to multiple offers. The currently inventory is very low in the state. So as a result, most realtors are dealing with multiple offer situations. The most frequent question I'm getting in that area is, A seller's agent calls and says, I have gotten several offers on the same property. What are my obligations? Do I need to disclose these offers to all of the buyer's agents? Well, this is outlined for the industry by standard practice 1-15. Realtors shall disclose with the seller's consent other offers on a piece of property. And then if they are asked where the offers have come from, they are obligated to provide information, again with seller's consent, where it came from. If it came from the listing licensee, the same firm as the listing licensee, or the cooperating broker. There are a lot of different ways to handle multiple offer situations. That you confer with your seller at all times, and you can accept the best offer. But when you say best, keep in mind best is different for all situations. It is up to the seller to determine what is the best offer. I do get a lot of questions from buyer's brokers who are sure that they submitted the highest financial offer, but that doesn't always mean that it's the best offer. Sometimes in the seller's eyes, there are other factors that would make it a better offer. For example, time of closing, or if it's an all cash deal, those kind of things can impact that. So that's up to the seller to determine best, and they're all different issues that would impact what would be considered best. You could inform all of the other parties to the transaction about the fact that there are multiple offers coming in. And then at the seller's direction, you could ask for the highest and best offer, but that's dangerous also. So you want to make sure that your seller understands what saying highest and best means, because essentially you are rejecting the other offers, or all of the offers that have come in. It's a rejection, and then you sit back and you wait for the parties to submit highest and best. So you want to educate your seller on the impact of stating highest and best. It sounds really great. It sounds like really powerful language, but it has other repercussions that the seller may not be completely aware of. You could counteroffer one of the offers that comes in with the direction of the seller, and then you could reject all of the other offers and just isolate your transaction dealings to just the one offer. Or you could counteroffer one and put the others aside while you wait to see what plays out with that first offer. Again, all of this is being done while you're educating your seller on what is happening. You try to foresee issues that could come from countering, and you try to operate, or you always operate at the direction of the seller. You always want to handle these situations very carefully, because you don't want to get a seller in a position where they have inadvertently actually accepted 2 offers from a buyer. So I always highly recommend that you talk to the seller and you advise the seller that they have these offers reviewed by their attorney and their own legal counsel to get independent legal opinions with respect to the offers that have come in. Another interesting question that comes about is, I'm getting a lot of calls recently from buyer's brokers, and they say, what do I do if I feel like the listing agent has not presented my offer to the seller? Well, that is also addressed under the Code of Ethics under Standard Practice 1-7. If you are the buyer's broker, you can make a written request to the listing agent to confirm if they have provided that offer to the seller. In return, once you make that request, the listing agent is obligated to either affirm that they've submitted the offer to the seller, or let you know that the seller has waived the opportunity to receive all additional offers. Another fallout from this low inventory situation, and in conjunction with multiple offers, are questions about contemporaneous offers. That's when you are a buyer's agent and you have 2 clients and they're both interested in the same piece of property. I get a lot of calls from buyer's agents asking what their responsibilities are in this situation, because they've got 2 clients that they are working with and they both love the same home. So that is also clearly addressed by Section 15-15B of the Real Estate License Act. There is no breach of duty by a licensee to show the same piece of property to multiple clients, and the licensee can prepare contemporaneous offers for the same property for two different clients. But in that situation, they do need to make written disclosure to their clients that that is what is happening, that they are submitting two offers by two clients that they represent on the same property. At that time, they also might want to present to one of the buyers or to the buyers the opportunity to be referred to work with another agent, because there are obvious conflicts of interest in these situations, and it's difficult perhaps to convince both buyers that you're acting as a fiduciary for both two people offering on the same property. If a client does request a referral, then you absolutely have to make a referral. Another question that I'm getting right now is, well, if I have these two clients and I'm pretty sure they're going to make an offer on the same property, at what point do I need to make the disclosure that there are contemporaneous offers or a potential for a contemporaneous offer situation? Well, the language in 15-15B makes it very clear that you need to do that at the time that you know or have reason to know that there may be a contemporaneous offer situation. And so you want to make written disclosure as soon as you even have an inkling that this is a position you might be put in. And also keep in mind that some of your offices might have an office policy that does not allow you to participate in a contemporaneous offer situation, and that you must refer one of the clients out to work with another licensee. Another issue that I'm getting a lot of questions about are escalation clauses, and these are very complicated. So an escalation clause usually presents itself in one of two different ways. In one situation, a buyer will want to put into their contract, into their offer, that the buyer will pay X. But if the seller gets a higher offer, the buyer is willing to increase their price or their offer to a capped price, and they'll name a price. And so in that situation, they're naming the very highest offer that they are willing to make. In a second scenario, the buyer may actually say that they will just pay X amount above the highest offer that comes in. These are very tricky situations. And if you're on the buyer's agent side, your buyer should consult with an attorney in the drafting of an escalation clause. They are tricky. It's legal work. As licensees, you shouldn't be participating in drafting legal clauses. So you need to make certain that the buyer is consulting with an attorney in those situations. Some other potential issues that can arise in these escalation clause scenarios are that when there's an escalation clause presented and your buyer has said that they will pay a capped price, sometimes it raises the seller's expectations with respect to what they might receive on a piece of property. And so in a sense, the buyer is kind of showing their hand. They're showing just how high they're willing to go. And so that can impact negotiations negatively rather than having the impact that the buyer hoped it would have. Another potential problem is that the buyer actually might feel very secure that if they write in an escalation clause that they are going to do this particular high price. Again, going back to that definition of best offer, that's not always the best offer in the eyes of the seller. And so sometimes a buyer can get frustrated because they think that they've done everything they can to absolutely secure the home that they want. And that's not always necessarily true. So you want to educate you always want to educate your client on the fact that these escalation clauses are not fail-safe. It's not a fail-safe method of bidding on a house, particularly now when inventory is so low and people are so competitive right now with respect to getting homes. The interest rates are low and people are being very aggressive. Another fallout, this is always a constant theme actually on the hotline, but I'm getting a lot of questions about procuring costs. One of the most frequent questions I get will be from an agent, and they'll call up and they'll say, I took so-and-so to see a house 3 weeks ago. And now they've gone and they've seen the same house using agent B, and they've made an offer on that house. And I'm the procuring cause, and I should be allotted a percentage of the commission, if not the whole commission, because I introduced them to the property. That is not necessarily true. First of all, the definition of procuring cause is, and this is loose and it's on our webpage though, procuring cause will be the agent who originated the chain of events without abandonment, meaning the agent leaving the client, or estrangement, the client leaving the agent, that leads to the successful sale of the property. So you have to think about that definition. Procuring costs can never be assessed until after there's a successful sale. In other words, the property has to have closed before anybody can weigh in on procuring costs. Also, licensees need to realize when they call the hotline, the legal hotline and IR legal, we will not weigh in on procuring costs. There's no bright line rule. It's not a black and white kind of a definition at all. As you can see, so many factors implemented. I tend to refer people who want to argue procuring costs to our ombudsman program, because our ombudsman program is available through our ethics staff, and it's a fantastic program. You can go online to illinoisrealtors.org and request an ombudsman, which is actually a third-party mediator. Somebody who's very well educated in what's going on in your area of the state will be contacted and become involved very quickly, and they will gather the facts on both sides of the transaction and between the two agents, and they will try to help the agents guide themselves to their own resolution, something that's to the mutual satisfaction of both parties. And it has a very high success rate. I think the last data that I heard was at a 67% success rate, where individuals feel really satisfied with the results of that program. The beauty of it is it doesn't cost you anything, and it's non-binding. So you can go ahead, you can try the ombudsman program, and then if you're not satisfied, then you can consider arbitration, which is really the only it's the only available next step. And there is an arbitration checklist on the National Association of Realtors webpage. It's a 17-point checklist. So if you think you're in a procuring cause situation, you think maybe you should file arbitration, I encourage you to go on the National Association of Realtors webpage and take a look at that checklist and review all of the points and see if any of those weigh in your favor. And that will help you evaluate whether or not you should file for arbitration in a procuring cause situation. Another topic that's hot in Illinois is the eviction moratorium issue. Many of you may know that currently in Illinois, there is an eviction moratorium in the state of Illinois, and our legislative attorney notified me 15 minutes before I came up here for this presentation that actually the governor today extended the eviction moratorium another 30 days. Also, the federal government has stepped in, and on September 4th, the federal government and the CDC, they issued their own moratorium. And under that moratorium, evictions are not available until the end of 2020. So there is a distinction in this. Right now, if you are in a situation where you think you want to evict a tenant in Illinois, you need to comply with the state's restrictions. And so the current evictions moratorium, the Illinois eviction moratoriums, are in place at least until the end of October. If that is not extended, then you would look to the federal eviction moratorium, which precludes landlords starting the eviction proceedings until the end of the month. There are some distinctions between the application of the state moratorium, which you would follow right now, and the federal moratorium. Some of the distinctions I'll just touch on very, very briefly, and we have a lot of information on those on our webpage. The federal moratorium is different because it does shift some of the burden to the tenant who is seeking relief from an eviction. And so a couple of examples are the tenant who is seeking the relief is required to fill out a sworn statement listing why they should qualify for some protection from eviction. And there are several criteria involved. It includes stating under oath that they have made an attempt to find housing. It includes they have sought government assistance for housing, and it also includes that they may have no other options other than to move into an occupied property and share space with other occupants, or they might need to go and move into a shelter where they would be exposed to unsafe health conditions. I encourage you to take a look on our webpage for the distinctions, and also that, you know, everybody should know that also locally, Chicago has its own moratorium on evictions, and other counties may have some, may implement some. So everybody probably needs to take a moment, if you're in the situation where you're trying to assess whether or not you can evict a tenant, take the opportunity to also look locally and see what's in place in your area in the state. One of the questions that I have gotten in the past and that's of concern, some people misunderstand that the moratorium on evictions does not mean that you will not collect rent from the tenant. It just means that they can't be moved. There is nothing about these moratoriums that is meant to stop a landlord from collecting the rent that is due to them while the party occupies the property. The effort in collecting it may be difficult, just under real world circumstances, but tenants are not given a free pass on payment of rent under these moratoriums. That's not the purpose. Okay, another question that I've gotten a lot of, and this is more COVID related, and this came as soon as we started opening up properties, the open houses and the tenant occupied properties. And that's the question of waivers. I'm getting a lot of calls from realtors who are involved in starting to be more active now. They're taking people in and out of homes, or they are opening up homes for open houses, and they're asking if we have waivers that we can provide that they can give to clients, either asking clients to disclose whether or not they've been exposed to the virus, whether or not they've had the virus, whether or not they've been tested for the virus, or on the flip side, waiving any liability from exposure to the virus in certain situations. We do not have such a form. Our legal staff has conferred. Our Betsy Irvance may talk about it a little bit in her presentation, I'm not sure, but our general counsel has advised that the causation factors with respect to this virus, there are too many unknowns. And so the waiver and any document that's similar to that probably doesn't hold a lot of weight down the road. If somebody gets sick 2 weeks after touring a particular home, linking the illness to the actual open house is pretty tenuous and very difficult. And so a waiver probably wouldn't hold much weight. And we just don't know enough about the virus, and we aren't medical personnel. And so we certainly can't evaluate that. If your brokerage does decide to implement the use of waivers and similar documents, you really need to consult with your legal counsel in the drafting, because it does involve asking for personal information. And also, you also need to think about applying it consistently. You can't ask for a waiver from some people and not ask for it from other clients. Make sure it's applied across the board in a consistent fashion, again, with the advice of independent legal counsel. Okay, finally, another issue that is on the horizon, and we've seen a little bit of it even here locally, that is the issue of scraping. Right now, the climate is hot for scraping real estate. And by that, I mean taking data off of real listings, the name, the address, even the photograph, other criteria or information that's on a web page, and copying it and putting it onto another platform. It's happening now because people are really vulnerable. There's a housing shortage, and people are being impacted very negatively in the financial side of things. And so people are getting a little bit desperate. Through these scraping scams, they put that information out there, inviting somebody to perhaps come and tour a house or put a down payment on leasing a piece of property through this fake posting. And people who are really desperate and looking for housing, they're willing to do that. So there are ways that realtors can protect their listings from scraping. And I suggest looking on the National Association of Realtors webpage. They have a YouTube video that I was fortunate enough to watch upon the advice of general counsel, just to it's very helpful that way. And so there are some ways to protect your listings though. There are things like Google Alerts, if this, then, and that, and Google Images. They are platforms that allow you to tag your own listing, put in the information and do a general search and get an email alert if it pops up on another web page without your permission. So in that way, you will know if your property has been lifted and placed maybe on Craigslist, or another platform that people are using is VRBO, perhaps Airbnb, other places like that where they're marketing out to those who are really looking probably for a rental. If it happens, you should notify the FBI because they do have an entire unit that is dedicated to looking into these situations. You could report this to the Illinois Attorney General's office or to your local authorities. Even your local state's attorney's office is a good resource. But we've seen a little bit of it already. We anticipate that that will continue. And so it's something that everybody should probably just be aware of it and be prepared to deal with it. So as far as the hotline questions go, that touches on most of the things, those are the hot topics that are coming in. But again, I'm still getting a lot of questions via the legal hotline that are COVID related. I can't say enough that our webpage has been expanded dramatically since last year to include an entire section on COVID related topics and FAQs. And the resources that are there are just absolutely incredible, and they're being constantly updated. Our legislative research attorney, Matt Rentschler, will continue to post updates on everything that the governor is doing as anything that impacts the real estate industry is being placed onto our webpage for you to look at. That doesn't mean don't call the hotline. That just means also consider the other resources that are out there. So thank you so much. And Betsy, I'm going to turn things over to you.
Hello, thank you, Annalise. Good, lots of really, really important and good information. I think I'll just do a little summation. I'll do like the 30-second summation because as you can see, I was taking a walk around the Capitol while Annalise was talking to y'all. And now I'm back in front of the Capitol's right outside my window. Insert wink and nod. So anyway, Annalise told us a lot of really great stuff, and I'm just going to remind folks just a little bit on a couple issues. Number one, escalation clauses. What if there are two? I'll just leave you with that question. And that will tell you how I personally, not a position of Illinois Realtors necessarily, is that escalation clauses just are icky. Number two, just to clarify, the moratorium on evictions is the residential rental moratorium on evictions. There is also a moratorium on foreclosure evictions that's in place. And now my mind's gone blank on the date to how long that lasts. I think that's mostly till the end of the calendar year also on the GSEs, like the Fannie Mae, the Freddie Macs, and the VA loans. So I believe I'm correct in that statement on the mortgage evictions. Also, be aware of the Emergency Rental Assistance Program in Illinois and the Emergency Mortgage Assistance Program in Illinois. Those are programs that are out there that provide funds to both tenants and housing providers who might be able to benefit from financial assistance. So just a reminder there. On the waiver issue, on waiver and causation, the causation issue is, to me, in the situation where we're in the middle of a global pandemic, causation is going to be really hard to prove unless you're the person who lived in a cave since February and you haven't come out yet, and then you show up positive. So causation, that's just a weird example to show you how that's going to be hard to prove. Although we are tracking legislation, federal, state, not sure which, but you are seeing some possible legislation. I don't think anything's in place yet, as far as it will provide businesses, healthcare providers, teachers, different folks, a liability or a waiver of liability. It'll be a legislative exemption from liability unless your conduct is wanton. And that's just a weird legal word for saying you're just not being cautious. And the way to be cautious is to follow all the guidelines that are out there. The guidelines for if your office building or your school or what have you is open, if your open house is open, have the signage, social distancing, PPE, all of that, make sure you're abiding by the guidelines. Oh, and the big one, wear a mask. That's not political. I think it's scientifically proven at this point that wearing a mask does help reduce the spread of COVID-19. It's really hard for me to not insert an expletive before the acronym COVID because we're all just tired of it. But you know what? This is our opportunity to meet these challenges, to come to you via virtual meetings, to still provide all the services that you need in this environment. So just get fired up and step up to the challenge of, of to make opportunities of the challenges we're presented. That's not legal. That's just a pep talk because deep down inside, I'm a coach somewhere. Annalise told you about the scraping. That's just Craigslist scam 2.0 or 3.0 or 7.0. And the other thing is if you happen to be a person that has your house listed for sale, the other way you can tell it's happening is you can look out your living room window and you can see some stranger standing in front of your house when another car drives up. And that's the person that's probably taken your for sale listing, put it on Craigslist or some other social platform offering your property for rent. So that's just one other way that you can tell. Not trying to be glib. I mean, that's really happened. So now I've got just a few minutes to share with you some other legal issues that we're tracking. I know there are some of you out there in virtual meeting land that really want rules, an update on the status of the administrative rules that we're just anxiously awaiting since August 9th, 2019, when the newly revised RELA became effective to be published. And we're still waiting. Checked this morning, the last step in the process before JCAR, the Joint Committee on Administrative Rules, publishes these draft rules is the governor's office. So not to throw governor's office under the bus, he's got a couple other things going on right now. So the real estate rules are there. And once they come out of the governor's legal counsel's office, I believe, per discussions with the Department of the Division of Real Estate, that those draft rules would be published pretty quickly in a matter of hours, if not hours, days by JCAR, where they would be available for everyone to read and make comment. So anything I say to you now, as far as the rules, is concept. It's conceptual. It's what we think the draft rules are going to look like, barring any drastic changes at this point by the governor's office, because everybody else has signed off. So a couple things, designated managing broker oversight. That's been a question of late on what the rules might look like. And just suffice to say that designated managing broker oversight has always been a thing. And there is a requirement for the designated managing broker, formerly known as the managing broker of the office, to oversee sponsored licensees. There are some now specific requirements in the Act at 10-55B for new broker licensees that have not yet completed their 45-hour post-license requirement. And now we're living in that environment where these folks are around and they need that oversight. The whole thinking at the drafting, not only of the rewrite, but of the rules, was that our new broker licensees can have a certain amount of education, 75 hours, and test, and then get into the practice, find out what real life is like, and then take some post-license education. But in the meantime, they sort of have a mentor or someone who can make sure that they're doing things correctly as opposed to just throwing them into the water and telling them to swim with all the appropriate strokes. So the rule, yeah, that's a nod to Annalise. She's a swim coach. So anyway, the rule is, or should be, that with regard to certain areas, that the oversight is the new broker licensees that haven't completed the 45-hour post-license education. I say a lot, so I'm sorry. I do that in live presentations as well as fake presentations. So oversight of all escrow handling must be done by the designated managing broker. Doesn't mean you can't, if you're a DMB, delegate that authority to your office manager, but you do have to make sure that you're in the loop. If you are still using paper checks, then you would have to have a procedure where you actually get a hand on that check at some point, or at least you know that your office manager has his or her physical hand on the check. So this is also another pivot opportunity to electronify, if that's even a word. If it's not, we just made it up, your office. So then if the earnest money is being transmitted electronically, the designated managing broker inserts themselves into the process and knows what's going on. Oversight of negotiations of purchase and lease contracts. DMB needs to be involved. Again, another perfect opportunity to use electronic platforms for those negotiations so that the DMB can be right there in the process and be the ultimate signer. Prohibiting new broker licensees, those who haven't completed post-license, from binding the company to contracts. So that would include your brokerage agreements. So you could have, if you're designated managing broker, you could have a policy that would allow your other brokers to bind the company, but your newbies, not so much until they've done the 45 hours. So keep that in mind. And there should be some rules language as to how to do that. My practical suggestion to you is work out those electronic platforms, unless you're a super small office and you can still handle things on paper. I'm a lawyer. I love paper and I love a real pen, but I'm trying to move myself into whatever century we're in. Finally, the oversight, make sure DMB is overseeing all the ad materials created by that new broker licensee who hasn't passed that education yet. The rules will have some sort of specific language. I think the rules will have some specific language about how to, that it's okay to delegate as long as you're in the process on all of those bullets that I just discussed with you. Also in the rules, and this will be new, and I just want to give a shout out to the department for working out some proposed rules that cover the practice of virtual office, which the way that I think about a virtual office is essentially operating the business of brokerage via a website. So as opposed to having a bricks and mortar office out there on the street, out right down the street from my Capitol here, where you walk into a physical office, you walk into virtually a website. So what does that look like? Now, what we've been saying, and we stand by, you could do a virtual office right now. The license law allows you to do it, but you have to practice in a manner that is analogous to how you would practice in a physical office. So when someone visits your website, so they get on your website and they haven't walked in the door yet, I'm doing air quotes here, they haven't walked in the door yet, so that's advertising. So on your homepage, what does it look like? Do they know your brokerage company? Do you meet all the advertising guidelines? Does the consumer know how to get a hold of your agents? Things of that nature. Now the consumer wants to establish a relationship with you, so they might even walk in the door. So when they walk in your virtual office, they're probably going to have to create some credentials to get in the door. So I think you can expect language like that to clarify how the virtual office would work. The department will want to keep track of virtual office. Back up one second, Bets. Um, the department will want to keep track of every office, whether it's bricks and mortar or virtual. So there will be a requirement to list office locations. There probably will be a requirement for some physical address, even if just a way to get a hold of you, even if it's not an office, but it would be a physical address, service, or process, some such thing. Um, Access will need to be controlled so that files are locked, electronic files are locked, so the designated agent and possibly the managing broker is the only one, the designated managing broker, has access to those files. So the way I've been thinking about it is access and permissions equals the new lock. If you can see that in your mind, where you have a physical lock on a door, you have a physical lock on a cabinet. Now you have access and permissions. So you have to keep that in mind. How are you going to protect the confidential information of opposing clients in a designated agency office? So there's that. And I gotta roll through. So the other really hot topic, I don't even want to call it a hot topic. It's just um, the topic of the day is fair housing, diversity, inclusion. We're witnessing the civil unrest. And I just want to slow down a minute, not going to be funny, which is easy for me to not be funny. But I just want to take a second to refer you to the Business Issues Forum that happened virtually here in these business meetings yesterday. Our chair and our vice chair, Jeff Gregory and Sarah Ware, respectively, hosted three awesome panelists. Jasmine Jefferson joined us from Washington State. So she was sitting in her living room with her air filters going. So that, and it was super early for her. Nate Johnson from St. Louis and Michelle Walker joined us, and for an hour, wow, was that discussion enlightening. Jeff and Sarah did a great job asking really tough questions of our three panelists. And just, I want to share with you some highlights. Just be careful. We as an industry need to be careful about how we're just not even, we don't intend to treat folks differently, but we just do with just everyday things like safety apps or apps that provide lead generation, or not paying attention to our policies and not having a consistent and orderly approach to treating every single client that we meet, no matter how we meet them. So that is just summing up like just volumes and volumes of information, but being consistent in having policies and being consistent in our treatment of others. And the coolest, it's a quote that Nate Johnson left us with at the end of that session. And it went something like this, and forgive me, Nate, if I'm messing it up, but it says something like this: if you are not intentionally inclusive, you are unintentionally exclusive. So just ponder that. Each and every one of us, no matter who you are, where you are, what you are, just ponder it, because we all, every single solitary one of us, has implicit bias or unconscious bias. We do. It's just, and there are tools to find out, to test ourselves. And I would encourage all of us to do that. National Association has an implicit bias test. And I don't know that there's a real way that you can cheat on it. So it's very, very informative for all of us. Another, switching gears here a little bit, another legal issue to place on your radar is website accessibility. We're seeing in Florida and New York lawsuits being filed alleging that websites are not accessible. And the There is a case, there's a seminal case out in California, and we've talked about it probably 3 or 4 times in other forums on it's Domino's Pizza, where a blind consumer was not able to order a pizza through the website and the app because he couldn't see anything. So this case has gone up all the way to the California Supreme Court, and finally that court said, look, even if there aren't federal rules that tell you what needs to happen on your website to make your website, which according to this case is a place of public accommodation and therefore under the federal ADA, Americans with Disabilities Act. So there's enough out there, there's enough guidance to tell you if you have the website, how you can make it accessible for maybe someone who can't see or someone who can't hear as well, or someone who is sensitive to flashing lights, and how you can make your website better so that that isn't happening for the consumer that's accessing your site. And this will apply to all of us that operate, well, us, we've got a website accessibility policy at the very bottom with all our other policies of our website. The Social Security Administration has a very good set of tools and guidance. I think our policy even sends you to the Social Security Administration site so you can see what your options are if you have a challenge for accessing information on a website. There's another source of guidance, which is I don't know how you say the acronym, it's WCAG, Website Accessibility, or excuse me, Website Content Accessibility Guidelines. And you can go there. It's, you can probably just make up the website, but it's HTTPS :// or is it forward slash? It's the slashes that you always see, www.wdigital3.org. ORG. So you can go find out a bunch of stuff about, or you can have your tech people, if you're lucky enough to have tech people, go find out the guidelines for making your website accessible. Just keep that on your radar, because when cases are being filed on the coasts, they're coming. So make sure everybody can use your website. I said about another zillion times before I got to this bullet. COVID related information. I'm not gonna be super into the weeds because our information is out there and we don't want to dwell on the fact that we're here. But I do want to remind you that guidelines are in place in the state. We're in stage 4, unless you're in a locality where you're being targeted or you're on a hotspot list. The governor's going to show up in your spot if you're on the hot list. And he's going to have a press conference and talk to you about how your guidelines are going to be a little bit stricter than the state guidelines. But same stuff, masks, hand washing, distancing. If you're having an open house, like Annalise said, my thought is if you're in the practice of real estate brokerage, if you're representing a seller, then treat your property as if everybody that's been in your house just now had COVID. So you're going to clean it up real good, right? So there's that. And then if you're on the buyer side, and you're going into someone's house, act like the sellers have COVID and don't touch anything. So, or have PPE, or be super careful, keep your distance, have your mask. So that could, I think, avoid a lot of problems. So keep that in mind, follow the guidelines. We're tracking relief packages at the federal level. There's one in the House, there's one in the Senate, and there's absolutely no agreement, but we're tracking it. So stay tuned to both National and Illinois Realtors for any new news on that. Make sure you have signage everywhere in your physical office if people are coming into it. And if you can operate remotely, that's still the safest way to be. I know a lot of my friends are still working remotely, especially the folks in Chicago, because, in Chicago, you have a 25% in an office building, just for example, you have a 25% capacity limit in the space or 50 people, whichever is less. But if you're 27 floors or 57 floors, how do you get them all up there if you're on the 27th floor and you can only put one or two people in an elevator at one time? It's just a practical problem as well as a health problem. Okay, where am I? I have 10 minutes. So let's talk about some cases to be aware of. This one comes out of Iowa from the Supreme Court of Iowa. And this to me is just, it's the, when I'm live and in person with you all in the audience, and this is a fact situation that I could count on one of you to propose to us. And you'll understand why in a sec. Okay, so you got a landlord and you got a tenant, and the tenant has severe allergies. Then you got a new tenant applicant who has a properly issued certificate from a psychiatrist for an emotional support animal. Okay, so what does the landlord do? The landlord does everything right in this case. The landlord consults with the Iowa Civil Rights Commission, or whatever they call the human rights agency in Iowa, and says, I'm between a rock and a hard place. What do I do? And they say, you need to rent to the person with the emotional support animal and make reasonable accommodations for both. So this landlord did just that, made reasonable accommodations for both, separated the tenants from each other by stairwell. And I don't know how big this building was. I'm feeling like it was kind of small, but still our allergic tenant was having, I mean, she had air filters put in. Landlord did everything right. And still she was having problems. So they end up in court. And who wins in that case? Well, in this case, and I will caution, very fact specific, and the opinion says this is very fact specific, but the allergic tenant wins because she was there first, essentially. So there you have it. But that was a long way of saying that. But the lesson of the case there is you have to balance the interests if you have two competing and very valid interests. And you always need to talk to your lawyers when this happens. So there's that case that's out there. And I just thought it was really, really interesting because the landlord did everything right. And the tenants, neither tenant really, neither one was at fault. So it's just that the allergic tenant wins because she was there first. We've got a couple Supreme Court cases to talk about, and you've probably seen these, but the first one is Bostock versus Clayton County. And I just want to tell you a little bit about it was three different cases. And just personally, I think it's nuts, but where is it? Okay, but anyway, you had somebody, here it is, found it. Here it is, Bostock. Okay, so in one case, you had a child welfare advocate who was fired for, air quotes, conduct unbecoming a county employee after he began participating in a gay softball league. Number two, in the second case, skydiving instructor was fired days after he mentioned he was gay. Third case, funeral home employee who presented as male when hired was fired when she informed her employer that she intended to live and work full-time as a woman. So you have orientation and transgender going all the way up to SCOTUS as this consolidated case. And what I also think is very, very, well, I'll just say awesome. Gorsuch, one of our conservative Supreme Court justices, speaking for the court, said that sex plays a necessary, sex is our protected class of the 7 in the federal law. Sex plays a necessary and undisguisable role in the decision, exactly what Title VII, referring to the Civil Rights Act of 1964, I believe I'm saying that right, forbids. I interrupt myself all the time. Those of you who know me know that I do that. The statute makes clear that an individual employee's sex is not relevant to the selection, evaluation, or compensation. So again, no matter what you think, under the Supreme Court of the United States, you cannot deny someone employment or fire them on the basis of sex, including sexual orientation or transgender. I will also make a programming note that Illinois statute already protects sexual orientation as a specific protected class. So it's a little bit stricter than the federal law. So we were already there, but I think that case is very, very interesting. And when I say I think, I mean I think. So whatever, but it's the law of the land. Another Supreme Court case, which is administrative, was Seal of Law LLC versus the Consumer Financial Protection Bureau. And what happened was the CFPB, that we're all in the industry familiar with now, went to Seal of Law and demanded documents that talked about the Seal of Law's debt relief services. And in my notes, I have a little question mark above that because I'm a little sketchy on debt relief services, depending on the facts, of course. There are good ones and there are not so good ones. But anyway, Seal of Law did not comply because they made the argument that CFPB as an agency or bureau, whatever you want to call it, was unconstitutional. Well, the Supreme Court took up that case and they split it in two. They said that the director was that the fact that the director could not be fired at will of the president violated the separation of powers clause between executive and legislative, or the pres and Congress. And Congress can't take that power from the executive, so that the director of CFPB, pursuant to this decision, now operates or can be fired at the will of the president. So in other words, you can't stay on from one president and not be fired, or his job isn't safe, or her job isn't safe. It's currently a her. Not that that matters, by the next president. However, they separated and they said the agency itself, the bureau, was constitutional, it's intact, it's still there. So another programming note is that the CFPB is now asking Seal of Law to produce those documents. Wink, nod, inserted. Where are we? Oh God, I've only got 2 minutes. Okay, so I'm going to pick the case that I'm going to talk to you about. It's a COVID case, so it's kind of miraculous that it's a reported case at this juncture. But it's Hits Restaurant Group. It was in bankruptcy court, and the restaurant in bankruptcy court, as I understand it, not an expert on bankruptcy, is that the commercial tenant is still obligated to pay rent. Well, the restaurant said, hey, look, because of the executive order in the state of Illinois, we're shut down, so we can't pay rent. The force majeure clause in our lease should be, and they invoked the force majeure clause, and they said, we can't pay rent, so we shouldn't have to. And the court kind of agreed. The court said, well, you can still do curbside and carry out orders, so you don't have to pay all your rent, but you got to pay 25% of your rent. So there you have it. The lesson of this case is force majeure clauses. If you are in business, you have contracts, and now every one of us is going to look at the boilerplate language in those contracts that may or may not include a force majeure clause. And if it does have one, we're going to be looking for pandemic, for governmental orders, business interruption. And I promise you that Illinois Realtors as an institution is doing that in all of its contracts, that it has some power to negotiate or change. So we are almost out of time. I want to tell you, when we sign off, there will be a screen that will allow you to send questions, because unlike in our real life where we can save some time to ask some questions, and that's way more fun, We don't have time to do that right now. Somebody else is in line for the next virtual meeting. So thank you, thank you, thank you for joining us today. I'm sorry I said or a gazillion times. Thank you, Annalise, for your interesting and the hottest legal topics. And thank you all. Stay safe and well and carry on.
Thank you, Betsy. My ahs were outweighed yours. I think I ahed 20 times more than you did. So
All right.
thank you.
All right, everybody. Take care.
Everybody should look at business issues from yesterday.